Edmonton, St. Albert.
Thank you very much, Mr. Speaker. It is certainly an honor for me to rise and add my contribution to the debate regarding Bill C-26, an act to amend the Criminal Code to deal with the important matters of citizens' arrest, the defense of persons, and the defense of property. Mr. Speaker, Bill C-26 will clarify for Canadians how they may respond to immediate threats to their property or to any person and criminal acts necessitating urgent arrest situations. Many members of this House will be familiar with stories, well-publicized stories, about Canadians being charged for crimes arising from situations where they were defending themselves, their family, or their property. We can all imagine cases where a person charged with a violent offense would claim that they had used violence to defend themselves without that necessarily being a true story. It is also likely that from time to time, someone would use a minor threat or insult as a pretext for launching a violent attack against another. So, Mr. Speaker, we want to make sure that our laws do not allow for such cases, because if this were so, many innocent Canadians could be victimized with no repercussions against the wrongdoer. But on the other hand, the law must also provide greater clarity for force that is authorized and must set out the conditions which that the aforementioned defensive action is acceptable. It is these very conditions that distinguish between revenge and genuine defense, and between reasonable and unreasonable conduct. Mr. Speaker, Bill C-26 extends the power of citizens' arrest in relation to property offences and clarifies the laws of self-defense and defense of property. These reforms are first and foremost about ensuring Canadians understand the law in this area and that they are able to defend their vital interests and apprehend wrongdoers. They are not required to stand by and watch their property be taken or destroyed, or a stranger get assaulted. When the police are not around, Canadians need not be helpless. They can help themselves and their fellow citizens, and where necessary, assist in bringing wrongdoers to justice. Mr. Speaker, the reforms are also intended to assist police and prosecutors who exercise their discretion on a daily basis in respect of charging and prosecuting, so as to minimize criminal charges being laid in situations where a defense is clearly available. Clarity in the law will hopefully weed out the cases of reasonable action, which need not result in criminal charges at all, and weed those out and distinguish them from cases where there are discrepancies in the accounts given by witnesses, or where the threat posed was small relative to the harm or injury caused, or other cases where there is some uncertainty about the reasonableness of the actions that were taken. Finally, Mr. Speaker, clarity in the law will help speed up the trial process when charges are genuinely justified. It will also reduce unnecessary appeals and save precious time for our admittedly overworked court system. How will Bill C-26 accomplish all of this? First of all, Mr. Speaker, it makes a modest extension of the existing power of citizens' arrest in the cases of property crime. Right now, currently, a person can only arrest another if they find them committing an act. This means that if there is no opportunity to arrest at the very moment, say for instance because the thief is faster and runs away, but there is an opportunity to arrest at some reasonable time afterwards, the law currently says that the arrest is unlawful. You literally have to catch the person in the act under the current law, Mr. Speaker. A person who's trying to bring to justice someone who has committed an offense or in relation to their property stands to be charged and potentially convicted of a serious criminal code offense that they may have committed in the course of apprehending the suspect under those circumstances. I hope that all members can agree, and it sounds like all members do agree, that allowing people to arrest within a reasonable time of having witnessed the crime makes good sense. We do not want to criminalize otherwise law-abiding citizens and business owners who are trying to protect their property from thieves and mischief makers. We know that situations do occur where the person observed to have committed an offense returns to the scene of a crime or is seen elsewhere and can be easily identified. Arrest should also be possible in these limited circumstances. But let's be clear, Mr. Speaker, that this proposal is a modest extension of the existing law. But I know that some Canadians are concerned that the proposed expansion of citizens' arrest power will encourage vigilantism. But I do not agree. The law of citizens' arrest already contains a very important safeguard against the arrestor using the laws for improper purposes. The safeguard, Mr. Speaker, is in the requirement in subsection 494 sub 3 of the Criminal Code that the citizen who arrests another must deliver the person forthwith to a peace officer. This requirement ensures that a citizen's arrest becomes a matter of police attention as soon as is possible. A new safeguard against vigilantism is included in this legislation, Bill C-26, in relation to the expanded power of citizens' arrest. A person will now be able to arrest someone who they have witnessed committing an offense in relation to property within a, quote, reasonable period of time, unquote, after the offense was committed. However, where a person seeks to use this expanded power as a precondition, they must first determine whether it is feasible for a peace officer to make the arrest instead of themselves. So there now is a double safety net against abusive arrests, where the arrest happens at some point in time after the original offense was witnessed. The citizen arrestor must turn their mind to the possibility of a police making the arrest, and if they determine that under the circumstances that is not feasible, once they have made the arrest, they must contact the police as quickly as is practicable and turn the suspect over. Of course, the overarching rules with respect to using force during an arrest also continue to apply. These rules ensure that a person making an arrest can use force, but any such force must be reasonable in the circumstances. If the suspect willingly submits to the arrest, then no force is necessary. If they resist, then some force may be called for, but the force must still be reasonable under the circumstances. Excessive force, Mr. Speaker, is by definition not reasonable. Deadly force, whether used by the police or by the citizen, can only be justified where human life is at risk. These rules are clearly set down in Section 25 of the Criminal Code, and Bill C-26 makes a reference to Section 25 so that it is clear to everyone which rules apply. Mr. Speaker, this legislation does not increase the potential for vigilantism. The government discourages vigilantism. Bill C-26 is designed to allow citizens to protect themselves and their property only when police are not able to do that for them. It strikes a reasonable balance. Bill C-26 does more than increase the period of time in which a citizen's arrest can be made. Citizen arrest situations will often overlap with the defense of property, Mr. Speaker. So Bill C-26 also ensures that the law governing defense of property is clear and effective. Today, currently, the defense of property is set out over 5 provisions that make many distinctions between slightly different circumstances, such as where the property in question is an object or land. There's no need for different variations covering different cases when they're all based on the same general principle, that a person should not be held responsible for a criminal offense if they act reasonable in an effort to protect property in their possession from being taken, damaged, destroyed, or trespassed upon. Mr. Speaker, C-26 would replace all of the existing rules with a single general defense that is capable of being applied to any type of property defense situation. And I must admit, I read the existing provisions just prior to standing up in the House, Mr. Speaker, and they are complicated and complex, and I had a difficult time applying each rule to a specific fact situation. So this is why C-26 clarifies the rules with respect to defense of property. This is precisely the sort of simplification that will help the police gather evidence and make decisions or recommendations about whether criminal charges are appropriate. It is also the kind of simplification that Canadians need. Mr. Speaker, property disputes often arise when someone is doing something unlawful, such as stealing a car or breaking into a house. But the defense can also arise in cases of genuine property disputes involving people who are all behaving lawfully but simply disagree about which of them is entitled to a particular item of property and what exactly they are allowed to do with it or not do with it. For instance, disputes over access to a right-of-way over where exactly a boundary is between two houses can and do lead to violence, just as conflict between a property owner and a thief or a criminal intruder can. The defense of property can apply to all of these situations. For this reason, Mr. Speaker, it is inescapable that matters of property law must inform the criminal defense of property. That is why the defense of property is premised on the concept of, quote, peaceable possession, unquote, of property. This concept has been interpreted by the courts to mean that the possession of property must not be seriously challenged by others. The seriousness of the challenge is assessed by looking to whether the challenge to the possession is likely to result in a breach of the peace. Of course, anyone who actually possesses property in circumstances that would involve a breach of the peace, such as protesters occupying a government building, should not be entitled to use force to defend their possession of that property in that circumstance. Another aspect of the law that Canadians should know is that our courts have consistently held that intentionally causing death in defense of property alone, as opposed to in the defense of a person, is never reasonable. Let me underline that, never reasonable. This principle is founded on the greater value to our society and to the value that it accords to human life over the value accorded to property. I'm sure we can all agree with this reasonable approach. Nothing in this approach limits the availability of self-defense, the other defense which is being simplified by Bill C-26. Any situation that creates a reasonable perception of a threat to a person, and this would clearly include a home invasion, or could even include a carjacking and other types of situations, gives rise to the ability to defend the person being threatened. Deadly force is permitted in defense of the person, but of course, as always, it must be a reasonable response given all of the circumstances. The proposed new defenses in Bill C-26 will capture the essence of the current laws, but in a much simpler way. The new laws will clearly and simply set out the conditions for defensive action. First, Mr. Speaker, there must be a reasonable perception of a threat to property that someone possesses. Threats to property can involve threats to damage or destroy the property or to somehow render it inoperative. It can also include threats to enter certain types of property without lawful possession, such as dwellings or other buildings or even a vehicle. Mr. Speaker, it is important to note that a person can be mistaken about the threat that they perceive. What matters in these cases is whether the mistake was one a reasonable person could also make in identical circumstances. We cannot take away a defense where a person behaved reasonably and perceived the situation in a reasonable manner, even if they were factually mistaken. But on the other side, if a person makes an unreasonable mistake, that is to say, if they fall below the standard of reasonable action and perception, they will lose the defense. And my friend from Vancouver Kingsway talked about the importance of the concept of reasonableness and the reasonable man in both civil and criminal law, and I agree with his interpretation and its importance to both these situations and to this legislation. The second element of the defense is that the person must genuinely act for a defensive purpose. Defense of property can never be a pretext for revenge. If the person doesn't really care about the property, but they use the other person's threat as an excuse to assault him or her, the law will not justify that conduct. And third, Mr. Speaker, whatever actions are taken for that defensive purpose, they must be actions that a reasonable person in the same circumstances could also have contemplated and taken. There is no way to describe what reasonable actions are, because what is reasonable to defend a particular item of property against a particular type of threat is likely to be different from actions that could be reasonable to defend other property from a more or less serious type of threat, which is a very long sentence to say that these situations are all fact-specific. It all comes down to the circumstances of each case. Mr. Speaker, these conditions are easy for Canadians to understand, and they should also be relatively easy for the police to assess and juries as well if charges are appropriate. Canadians will understand that they must genuinely be acting to protect property and not acting to take revenge against someone. They also understand they must conduct themselves within socially acceptable standards within which a range of conduct is likely to be reasonable. As long as Canadians bring themselves within this range, they will be justified in using the force that they need to in order to keep themselves, their families, and their homes safe. Of course, Bill C-26 also brings greater clarity and simplicity to the defense of self-defense. The proposed new defense would also apply in cases where a person uses force to protect a third person. Today, the Criminal Code says that a person can only defend another person who is, quote, under his protection. The courts have given this phrase different meanings, and it is not clear, as it should be, that citizens can defend not just their children or their elderly parents, but they can also defend their fellow Canadians, even strangers, Mr. Speaker, when they come upon them in a situation that presents a grave threat. This bill is clearing up this aspect of the law, and appropriately so. But the reforms to self-defense do more than just that. They also simplify the law in other ways and bring a variety of different rules into one single rule that will be applied no matter what the circumstances. The basic elements of self-defense mirror those of defense of property, but they are even simpler because complicated property concepts are not involved. Right now, there are 4 separate sections of the Criminal Code that set out various versions of the defense of the person, each of which applies in a slightly different set of circumstances. The law simply is way too complicated and confusing. The fact is, such complexity is unnecessary because the basic elements of the defense are relatively straightforward, and Bill C-26 seeks to reduce the defense to its core elements. The conditions for defense of the person are under Bill C-26. And they can be stated briefly, Mr. Speaker, because I suspect I'm running out of time. They are, maybe not. So I can explain them in some length then, if you're interested. They are, firstly, the person reasonably believes that they or another person are being threatened with force. 2, the person act for the purpose of defending themselves or the other person from that force. And 3, their actions are reasonable in the circumstances. Now, as with the defense of property, Mr. Speaker, mistakes can be made by the defending person, so long as those mistakes are reasonable. The defending person must genuinely be acting with the defensive purpose and must not be using the threat as a pretext to engage in violence that they otherwise desire to engage in. The reasonableness of the actions taken in defense of the person must be assessed in relation to all the relevant facts and to all the relevant circumstances. In this last regard, Mr. Speaker, Bill C-26 does propose a list of factors to help guide this determination. These factors frequently arise in the self-defense context. Factors on this list include whether any party had a weapon, the nature of the threat that the person was facing, whether the individuals involved had a pre-existing relationship, especially if it is a relationship that involved violence or threats. And of course, the proportionality between the threat and the response will be a critical factor in determining whether or not, under the circumstances, the defense was reasonable. Mr. Speaker, these factors are drawn from real cases and from the court's interpretation of the current law. The purpose behind these provisions is to signal to courts, as well as to police and to prosecutors, that the essence of self-defense is not changing. Reasonable actions under the current law should continue to be reasonable under the proposed new law. These are the sorts of determinations our courts make regularly. But, Mr. Speaker, by simplifying the law, by clearing away the clutter and putting in the Criminal Code the crucial questions and crucial factors, Bill C-26 is clearing the path for them to get straight to the important questions. The bill is also making it easier for police at the scene of the crime to apply the law before making charging decisions. Bringing clarity to the law will make that legitimate self-defense actions lead police and prosecutors toward the decision that laying a charge would not be in the interests of justice. In this way, this bill continues to stand up for victims. It's a delicate balance, Mr. Speaker, but as the speakers previously have said, we believe that this is an appropriate balance the rights of individuals versus the rights of people who cause threat to those individuals or to their property. And I look forward to questions from members of the House.
Questions or comments? The Honourable Member for Pierrefonds-Dollard. Thank you, Mr. Speaker. My colleague mentioned that the government will support the bill, or rather, we will be supporting this bill in second reading so that it can go to committee. But we don't want to facilitate excessive reactions. So I would like to ask my colleague whether the legislation should maybe change some of the terminology so that we don't have people using force in cases of theft or possibilities for people to take revenge and have reactions that we don't want.
In St. Albert.
Well, thank you, Mr. Speaker, and I thank the honourable member for her good question, and she's right. I'm on the Justice Committee, I'm on the Public Safety Committee, and I do know that when this bill was being drafted, great consideration was given not to send the signal that vigilantism is to be promoted or encouraged, or that individuals ought to take the law into their own hands. So this bill, I think, and I think as other members from that side of the House have correctly pointed out, strikes a very, very close balance. And I admit, I mean, there are cases that come close to that line. But nonetheless, as legislators, we have to try to balance the rights of individuals to protect themselves and protect their families and protect their property against those who would cause harm to it. The issue becomes one of reasonableness. And the test will vary from situation to situation. I represent urban constituents where access to the police is relatively expeditious. Individuals in rural and remote areas have different challenges. But the test under each circumstance, and I said in my comments will be fact-specific, is one of reasonableness. If a person acts reasonably, they will have the protection of this offence. If they do not act reasonably, they will be charged.
Questions and comments? The honourable member for Charlebourg-Outrin-Charles. Thank you, Mr. Speaker. We are currently dealing in our society with a small group of small group of people that patrol a part of their city, and they are substituting themselves for police officers. They arrest other citizens, and often they don't take the time to check to see whether a police officer is available or could come to the scene. Is this member not concerned that this legislation might encourage that type of reaction and that we might have this kind of vigilante justice? So my question is similar.
Edmonton, St. Albert.
Thank you, Mr. Speaker, and I thank the honourable member for, again, a very good, albeit quite similar question. In my constituency, we too have those types of groups, although they are very passive. They're concerned, called Neighbourhood Watch, for example, where neighbourhoods watch out for suspicious activity in their neighbourhoods and then contact the police. But and I don't know exactly which groups she's referring to in her riding or elsewhere. But I'm not concerned that this legislation will give license to vigilantism, whether it's organized or otherwise. This law makes it very, very clear and very specific that police are to be called as soon as possible when it's practicable, and the rights to self-arrest or the rights for citizens to make arrest are very limited to circumstances where it is not practicable to call the police, and when you use only reasonable force, and when you turn the individual over to the police as soon as is practical. So quite the opposite. I think this law clarifies to potential groups who take it upon themselves to provide for safety for their neighbourhoods what they can and cannot do legally.
Questions and comments? The honourable member for La Salle-et-Mar.
The member from Edmonton, St. Albert, for his presentation and clarification. I find that Bill C-26 and the example that is in the House presently in reasonably discussing a bill is a very good exercise, and I really appreciated his presentation. I noted in his presentation also that I think that he has a lawyer background, that he was mentioning that just for this bill and this special provision, the criminal code is very complicated and complex. And I wanted to compare and contrast with the Bill C-10 that we just has passed in the House, why that bill that contained very many provisions of the criminal code, why didn't we have the same approach as breaking down the Bill C-10 as the exercise we are doing right now with the Bill C-26?
The honourable member for Edmonton St. Albert.
I'm not sure that I fully understood that question. What I said in my comments is that this bill, the bill before the House, C-26, clarifies the existing provisions, specifically sections 34 to 42, which create a rather complex and convoluted set of circumstances with respect to when reasonableness and defense of property would apply, depending on whether or not it's real property or whether it's not or whether it's personal property, and that this bill aims to, and I think succeeds in that aim, in clarifying the when the defense of property and when the defense of the person will apply. She made some reference to C-10 that I did not quite understand, but certainly this bill fits in the entire umbrella of philosophy between this bill and C-10, in that the government continues to stand up for the rights of victims, and this bill fits into that umbrella because when victims of crime take measures to defend themselves or to defend their property, as long as they act reasonably, they ought to have the protection of the law.
Questions et commentaires.
Questions and comments. The honourable member for Pierrefonds-Dollard. Thank you, Mr. Speaker. My colleague for Edmonton St. Albert said that he was on the Justice Committee, so I would like to know, well, there is no doubt that the criminal code is complex when it comes to legitimate defense and the defense of property. My colleague, the member for St. John's East, mentioned his expectations that the committee would seriously consider this bill to see whether there were possibilities for changes to further refine it in terms of legitimate defense, self-defense, and the defense of property. I'm wondering whether my colleague is open to hearing from expert witnesses and making some amendments in committee.
Edmonton St. Albert.
Thank you, Mr. Speaker, and again, thank the honourable member, all the honourable members for their good questions. Yes, the Justice Committee, assuming this bill passes the second reading, and it appears it will because I think it has support from all sides of the House, the bill will go to committee and the committee will call expert witnesses. And as I indicated in my comments, and I think the NDP Justice Critic and certainly the member for Vancouver Kingsway, this is a good bill in principle, but it is a delicate balance to weigh the rights of citizens versus the rights of those who potentially cause harm to those citizens. So, yes, we will vet the language. We will call on experts from victims groups, from police groups, presumably from academia, like we do with every other bill. And if it is appropriate to make technical or linguistic amendments to this bill to make it more precise, we'll do it. And in fact, the opportunity for making modest amendments is presumably more likely in a bill where there's actually philosophical agreement with the contents of the bill, and we don't use the committee as simply another mechanism for the opposition to oppose the bill. This committee will actually meet purposely to try to make sure that the bill has the appropriate language to make the appropriate balance between citizens and those that cause harm to citizens.
Resuming debate.